libreria dei podcast della Corte Costituzionale.
After having read Silvana Sciarra's excellent text, that the right question is not who has the first word, who has the last word, but how are we achieving common words? I am hesitant now to speak because maybe I had the first word and now I may be seen as having the last word, but that's not the intention. The intention is to underline, sottolineare, what the common words are. And I think throughout the two parts of this day, we have, at least as far as I'm concerned, felt a real exchange and shared concerns of what is preoccupying us. And of this morning's exchange, I retain that the sometimes perceived tension between national identity and primacy should be qualified in many ways. In fact, to a large extent, it is like Justice Emanuela Navarretta said, the good balance between uniformity and diversity, uniformity and pluralism. And in that sense, I must say that the constitutional courts, and I'm also referring here to the German Constitutional Court, has picked up, who would have thought it in 2013, the summa divisio between Meloni and Aukerberg-Fransen, or for that matter, Tarico too. I mean to say, the distinction is now almost generally shared that where union law has fully harmonized or determined, like for the European arrest warrant, the conditions of operation of an instrument of union law, then solely the Charter of Fundamental Rights is the human rights standards, no more, no less in the member states. However, that is only for those subjects where the union legislation doesn't leave the slightest political judgment or appraisal to the member states. That is what the Bundesverfassungsgericht has included in its Recht auf Vergessen II, a judgment of the 6th of November 2019. The other hypothesis, far more frequent, is Aukerberg-Fransen or Tarico too. That is that the Union has possibly unified some rules, but leaves an important margin of political choice to the member states. And that, in that case, it's paragraph 29 of Aukerberg-Fransen, the two judgments are of the 26th of February 2013. You will see in that paragraph that in that case, it is the national constitutional standard which should be applied first. Of course, that standard must minimally correspond to what the Charter protects, because we're still in the field of implementation of union law. But it can be tested. In other words, there, the member states can apply a higher standard of protection of some rights, provided that they achieve the outcome commanded by union law. That is what goes behind this triptych of unity, primacy, unity, and effectiveness of union law. And of course, a directive worthy of the name normally leaves a wide margin of choice as to the means to achieve the outcome which is commanded by union law. So there a constitutional court can perfectly annul a law implementing a directive, telling the national legislator you should do the homework over again. This may be in compliance with the Charter, but it's not in compliance with our own constitution, and we protect better. So the summa divisio between subjects which have been wholly determined by union law, which happens, think about GDPR, the General Data Protection Regulation, that was the case of Recht auf Vergessen II, but in the GDPR there is the protection of journalism, and that is only a minimal indication. Recht auf Vergessen 1. There the member states can apply their own standards. Our code, has now increasingly fundamental rights cases which leave the margin to the member states. I give you one example. Israelitisch consistorie van België, it's a Dutch language case from Belgium, a reference of the Belgian Constitutional Court, your direct colleagues in the Kingdom of Belgium, and it was about the combination of the freedom of religion with ritual slaughtering. A directive saying that in principle that should be after stunning of the how do you say that, the cattle, the stunning of the animals. And of course, the member states have very divergent views on the balancing of animal welfare and expression of religion. So we gave some minimum indications, but saying that the final balancing has not been operated at union level. Recht auf Vergessen 1. There is freedom of choice for the member state to make their own balancing. There were nevertheless minimal rules to be respected, that the slaughtering needed to take place in a specialized slaughtering house and things like that. But you see, there are now Grand Chamber judgments which bear that out. The headscarf cases. The headscarf cases, the religious signs in the workplace, where we said member states have very different views as to the wearing of religious signs, for instance, in public office. There are member states where you can have a civil servant somewhere putting a public service wearing the headscarf. No problem. Other member states say, no, that is against neutrality. But even the word neutrality is 180 degrees the opposite in France and in Germany. In France, it is said, nothing goes. That means banning of all religious signs, because that is neutralité, laïcité. In Germany, neutrality is everything goes, and everyone should tolerate what all the others do. So even the rhetoric is very different. So we have, in our case law, accommodated non-discrimination on the basis of religion, but there are possibilities in the directive, Article 8, the famous Directive 2000/78, where member states can protect better. You can say, well, equality, it's either or. But no, it's in the directive, member states can protect better. We use that clause to say, well, look, there is no uniform standard everywhere. There can be a balancing. And of course, the Conseil Constitutionnel in Paris comes out on the side of laïcité, and the Bundesverfassungsgericht applies the 4 articles of the Weimarer Reichsverfassung, which have been taken up in the Grundgesetz, and which some of you know very well. So that is really what happens. So we are very much aware of this balance between uniformity and diversity in our own case law. We're past the stage where our code was only dealing with free movement of goods, services, and capital economic matters. We are now doing the same type of work as a constitutional court does, but then accommodating the diversity of Europe at large. I was very happy with the remark of our first Advocate General underlying the distinction between supremacy and primacy. In fact, the best reading of that distinction you find in a judgment of the Spanish Constitutional Court. That is the judgment of 2004, the Tribunal Constitucional in Madrid, when they had to rule on the compatibility with the Spanish Constitution of the Constitutional Treaty, which was not ratified as such, but which is for 90%, as we all know, in the Lisbon Treaty. And they explain exactly what our colleague said earlier this morning. Primacy is a conflict of laws rule. It is when 2 rules collide, it's sort of rational to have the common rule for reasons of equal treatment and all what we discussed today. But it's only a conflict rule. There is no superiority intrinsically of one legal order over another legal order. The whole idea of the European Union is a network, not a hierarchy. It's a network, and the Court of Justice our court is there to make the network operate coherently and interactively. So the primacy is the correct rule. And of course, primacy only leads to the setting aside of conflicting rules when the European Union rule has direct effect. And as Francesco Vigano said very clearly, the court has now increasingly recognized direct effect, expressly or impliedly, to charter rights and principles. In the criminal law field, it's clear, but also the non-discrimination cases, Cresco investigation has been quoted, but also for the annual leave cases, Article 31, paragraph 2, etc. So the fact that we require direct effect of a rule of union law before that rule's primacy can lead to the obligation to set aside conflicting national laws puts some pressure upward to recognize direct effect. And you saw it in that case recently, Grand Chamber. It's unfortunately again one of these cases with initials anonymized. It's EK, but it won't tell you anything. It's this judgment of March or April of this year about the proportionality of the sanction. That, in fact, was a Grand Chamber reversal of Link Logistics, which went the other way after an excellent opinion of Advocate General Bobek. But it shows that we might be slightly more willing to recognize direct effect when it is a fundamental principle or rule of union law which is involved. And that leads, under Poplavsky too, to the full effect of primacy. As far as this afternoon session is concerned, I think it is extremely important that we leave with the idea, that we sort of leave this working day, with the idea, the judiciary of the European Union, that is not Luxembourg. It is the national courts. And to put that more sort of provocatively, to fix our ideas, all litigation between private parties, I say all litigation between private parties, as well as all litigation between, on the one hand, a private party, and on the other hand, a public party not being an institution or body of the Union, that is any national authority. All these disputes, without a single exception, are pending before the national courts. The national courts are the EU courts of general jurisdiction. Les juges de droit commun, as they say in French. I have translated that in my publications, the courts of general jurisdiction under EU law. And our court only intervenes when those courts want to be sure that the interpretation that they are inclined to adopt of union law corresponds to that which should be valid Europe-wide. That is why courts of last instance, I said it this morning, are obliged to refer. It's also why only independent and impartial courts, Banco de Santander has been mentioned, can refer to us. Because we must be sure that those courts are at an equal distance of the two parties, including when the defendant party is a national authority of the member state concerned. Hence the importance of our independence debate this afternoon, that they identify the issues of union law, refer the matter to the Court of Justice, and thereafter faithfully enforce and apply the judgment. Now, national courts, and especially national constitutional courts, they should, I think, see this obligation to refer not so much as an obligation, but as an opportunity. Because if you take the initiative to introduce a request for a preliminary ruling. Then you set the framework within which the debate will take place. And not only that, we encourage especially constitutional and Supreme Courts of the member states, like you did it in the Tarico II reference, to explain what you as a constitutional court would do in terms of the national constitution. Why is that important? You should know when such a request comes in our court, like the two now pending cases on the European arrest warrant, and combination with one of which is, I look at Francesco because he was the reporting judge in these cases, we will have oral argument before the Grand Chamber of the first one of the two, now on the 27th of September, this month. So it is, you set the stage, you explain what the requirements are of Italian constitutional law, how you feel about it. The first thing which happens when such a judgment comes in, it is translated into all 23 other languages. It's important that you visualize that. Then it is notified to all 27 member states. They all come in with their comments on what you have written. So if you say what you would yourself think, there are lots of member states saying, yes, that would also be the case with us. Or no, that might be different with us for the following reasons. So you set in a way the standard, the measuring stick with which the debate will be conducted. And afterwards, the deliberation takes all of that into account and comes to an interpretation which can hold Europe-wide. So constitutional courts referring to us, they take up that opportunity to set a stage. That is why the German Constitutional Court changed its attitude through Recht auf Vergessen 1 und 2, saying we will ourselves refer. You know what they did before that, you know this. They in fact did not refer. They annulled the judgment after Verfassungsbeschwerde of the Supreme Ordinary Court, Common Court, whether it's the Bundesgerichtshof, Bundesverwaltungsgericht, Bundesfinanzhof, etc., and then ordered that court to come to us. But of course, doing it that way, they lost the opportunity to set themselves the stage. And now they announce we will do it ourselves, which the Corte Costituzionale does already for decades, and the Belgian Constitutional Court as well, the Austrian, the French, the Baltic Constitutional Courts, etc. So I think that is very, very important. And of course, and I conclude by this, I think that the main impression which I will take with me when we return tomorrow, that is that we are really together in this. We must make the European space work as an area of liberal democracy based on the rule of law and on fundamental rights. We are allies in that. We read one another's jurisprudence and we come out stronger. If you see the threats also geopolitically on our borders by authoritarian regimes which are breaching the most fundamental rights, then I think we don't have the luxury to quarrel among ourselves, but we should know that what unites us is much stronger than what divides us, and that what unites us leaves sufficient room for unity in diversity for everyone to feel comfortable in the common legal space.